Today, I'm going to help you decide what to do in a situation where a carrier has denied a cargo claim and your shipper is very upset. I'm Cassandra Gaines. I'm a transportation attorney and a consultant. My job is to teach you how to handle these day-to-day issues and how to not hire a lawyer. You can do this stuff yourself, guys. Now, my client has emailed me and said, Cassandra, I have a motor carrier who's denied a cargo claim. He states that the goods were delivered in fine condition. They were boxed mac and cheese, and the consignee rejected the shipment unreasonably because the goods were leaning. Now my shipper is very angry with me and refusing to pay. Here is what I suggest. I've run cargo claim departments before. So there's a legal answer and then there's a practical answer. I'm going to give you the practical answer because our job as a broker is to get these cargo claims resolved. Often it's very hard and we can't do it, but we try our best, right? So in this situation, if it's a fresh situation where the consignee has just rejected the goods, you want to try your best to encourage whoever has custody of the goods to open some of the boxes. Maybe the carrier will even pay for the boxes that are opened. Take pictures. Examine how were the goods really treated when they were leaning. Did the shrink wrap get damaged? Did it actually break open? Were the boxes broken open? Or was the consignee being a little bit unreasonable? This information is what you need to help both parties come to a solution. Now, you're going to turn around and tell the carrier, I understand that you believe from the face value of this claim that the goods were fine. But your legal responsibility under the contract, under Title 21, is you have to prove that the goods were not damaged. Because under Title 21, the definition of adulterated goods is really broad, guys. And so you may want to use this information to the carrier or the carrier's insurance adjuster. Tell them to Google 21 USC 342. There's your definition of adulteration, and it's pretty broad. It says that the goods may have been contaminated. Here, the goods shifted and they were leaning, and the consignee thought they may have been contaminated. Now it's the carrier's job to prove that the goods were not contaminated. Pictures, opening up boxes, that's the way you do it. And you want to encourage your carrier as much as possible to take these steps because you're trying to resolve the situation. And then you're going to turn around and talk to your shipper. And you're going to use the carrier's arguments, which are, hey, the goods were simply leaning. From what I can see here, there was no damage to the goods and the consignee is being a bit unreasonable. I know the shipper's not going to want to hear it, but your job is to be a mediator and try to get the situation resolved. If you can't, then sometimes you're going to have to turn around and tell the shipper and the carrier they're going to have to figure this out on their own. There's only so much we can do as brokers. Now, another tip for you to remember is to check the contract with the shipper. And sometimes the contract has more details going beyond Title 21, going beyond the Carmack Amendment, more restrictive that would apply here. You also want to check and make sure you're not liable as a broker for the cargo claims. And if there's no contract, you'll be governed by what I say in my video. So here's the other thing with the carrier is you need to remember, maybe not use this carrier again for a cargo claim. For a shipment of food. You're going to have to decide, but I wanted to go through the analysis because I can see where the carrier is coming from. But again, do you want to keep having these types of problems? Especially if the carrier doesn't cooperate with trying to gather more evidence for you. So these situations are how you're going to try to get both parties to resolve the issue.